we are done with um, um, receivable and voidable contracts. And to finish the coverage of contracts, we now proceed with the discussion of unenforceable contracts and void and inexistent contracts. So unenforceable contracts are identified or enumerated in Article 1403 of the Civil Code. Sabi niya, the following contracts are unenforceable unless they are ratified. So ibig sabihin, um, wala muna silang effect, they cannot be enforced in court, they are unenforceable unless you ratify them. Okay, so minsan ang tawag sa ang tawag sa unenforceable contracts ay validable contracts. So ibig sabihin ng validable, they are unenforceable, but if you ratify them, you can give effect to unenforceable contracts. In which case, hindi na siya unenforceable kasi you are ratifying it and you are enforcing the terms of that contract, which is otherwise unenforceable. Okay. So tatlo, nabanggit ko dun sa introduction natin on defective contracts. Sa tatlong paraan naging unenforceable ang contract. Una, may question about authority. Pangalawa, may non-compliance with the statute of frauds. Pangatlo, both parties are incapacitated to give their consent to that contract. So number one, those entered into in the name of another person by one who has been given no authority or legal representation or who has acted beyond his powers. So we have here, ay, lumipat siya. We have here X and Y. Tapos si X, meron siyang kotse. X owns a car. Ito si Y, without being authorized by X, ginawa sa kotse ni Y, ni X, pinaupahan niya. He entered into a lease contract with Z involving the car of X for the rent of the car. So may lease agreement between Y and Z, but the subject matter of the lease agreement is the car owned by X. X not authorized by Y to do such contract. So that contract is unenforceable because it is unauthorized on the part of X. O kaya naman, the person exceeded his authority. Okay, sabi ni X kay Y, this is my car and I am authorizing you to sell it for 1 million. Si Y, naghanap ng buyer, si Z, binenta niya kay Z for 900,000 on installment. Mali na nga yung presyo, kakaiba pa yung modes of payment niya. Inutusan naman siya ni Y, kaya lang in excess of the authority given by. O kaya sabi ni X kay Y, itong kotse ko ay ipahiram mo. Yun yung authority, ipahiram. Ang ginawa ni Y, pinaupahan. Ang utos, ipahiram, tapos ginawa niya, pinaupahan. That is beyond the authority granted by X to Y. May authority pero lumagpas sa authority. Dito sa kabila, una example natin, wala talagang authority. So the lease contract between Y and Z involving the car owned by X is unenforceable. The lease contract between Y and Z is unenforceable because X only instructed Y to make a contract of comodatum. Pahiram daw. Hindi niya pinahiram, pinaupahan. Unenforceable yan. Okay? So that's the first, unauthorized or in excess of authority. Pangalawa, those which do not comply with the statute of fraud. So ito yung sinasabi natin, medyo matagal na rin na there are certain contracts which are required by law to be in writing, to be enforceable. To be enforceable. Not to be valid, ha? To be enforceable. Ano ba yung statute of fraud is? And why is fraud included there? For example, sabi niya, okay, I will sell to you my cellphone 2 years from now. Bago kasi yung cellphone ko ngayon. So pag medyo na luma na siya, 2 years from now, bibenta ko siya sa'yo. Ngayon yung agreement natin. 2 years after, itong intended na buyer, sabi niya, o di ba sabi mo 2 years ago, ibibenta mo sa akin yun? Sabi niya, may sinabi ba akong ganun? May sinabi ba akong ganun? Eh, sabi niya, yun yung sagot niya. Oo, meron ka sinabi ganun. Hindi, wala akong sinasabing ganun. Niloloko mo ako eh. O, parang fraudulent, di ba? Parang fraudulent. Parang may panlolokong nagaganap. Pero today is not really the fraud that we have learned before. Pero, kung sakali lang na isulat ito, hindi sana nangyari, hindi sana humantong pa sa ganong pananalita. Niloloko mo ata ako eh. Parang ganun. So, since nire-require ng batas na isulat nyo ito para maging enforceable, kailangan siyang isulat. Diba sa forms of contract na pinag-usapan natin, if the law requires that a certain contract be reduced in writing for it to be enforceable, that requirement is indispensable. Kailangan mo siyang sundin. So ano-ano yung mga nakalagay sa Statute of Frauds? Una, an agreement that by its term is not to be performed within a year from the making thereof. An example ko. So merong agreement pero future yung agreement. Ngayon tayo nag-uusap, sabi natin in the future, 1 year from now or 2 years from now or 5 years from now, let us enter into a contract of whatever. Contract of sale, contract of partnership, contract of lease, ganyan. Ay, may kotse ka. 2 years from now, upahan ko yan. Whatever it is na napag-usapan nila ngayon, but it will be performed within a year pa or 2 years or beyond. Yan. So if you want it to be enforceable 1 year after or just sa future na napag-usapan ninyo, make sure na ngayon, isusulat mo siya para maging enforceable siya. Kasi if not, it is unenforceable. Hindi mo siya mapipilit na, oy, napag-usapan natin 1 year ago. Nabibilhin mo to or upahan mo to or gagawa tayo ng contract of partnership or agency or mortgage or etc. etc. Sabihin lang niya, wala, nakalimutan ko na yun. Hindi mo sinulat. So, medyo tagilid ka doon. Ikaw yung medyo mawawala ng karapatan. So if you want to protect your right or your client's rights for that matter, make sure you reduce it in writing. Letter B, a special promise to answer for the death, default, or miscarriage of another, like a contract of guarantee. Diba? Ang contract of guarantee, it is a special promise to answer for the obligation or the default of another person. Para ang undertaking ang promise or undertaking ng isang guarantor is that pag yan si debtor hindi nakabayad, ako mananagot. Yan. So if you want that promise, that guarantee to be enforceable, you have to ask the guarantor, or really, will you answer for the failure of the debtor to pay his obligation? Yes. So sulat natin yan. Kasi pag di mo sinulat yan at hindi nakabayad yung debtor at you try to collect from the guarantor, sabihin niya, wala akong maalalang sinabi kong gano'n. Parang wala naman akong nabanggit. Yan. Eh kung sinulat mo yan, tapos na ang usapan. 1403. Letter B. Letter C. An agreement made in consideration of marriage other than a mutual promise to marry. An agreement made in consideration of marriage. Sabi niya, okay, pag nagpakasal kayo, XY, pag nagpakasal kayo, bibigyan ko kayo bibigyan ko kayo ng sasakyan. Bibigyan ko kayo ng sasakyan, promise. Gusto ko kayong magkatuluyan, bigyan ko kayo ng sasakyan. Ano gusto mong gawin? You have to reduce it in writing for it to be enforceable. An agreement for the sale of goods, chattel, or things in action. Ibig sabihin, any property which is not immovable, chattel, goods, things in action, at a price not less than 500. So we have here the threshold amount of 500 pesos. Sabi, bentahan natin to kotse, cellphone, magkano? 600. Uy, mura. Bilhin ko na. Sige, balik ka sa akin bukas. Okay na bukas. Nasaan na yung cellphone? Anong cellphone? Yung bibenta mo 600, wala. Walang ganun. Hindi, nag-usap na tayo eh. Na bebentan. Ano yung napag-usapan natin? Oh, magkano? 600. Aba, pag lumagpas ka ng threshold na 500 at hindi nakasulat yung contract na yan, unenforceable. Pero sabi niya dito, unless, may exception dito eh. Unless, yan. Unless the buyer accept and receive part of such goods or chattels, or the evidence, or some of them, or pay at the time some part of the purchase money. Kapag may partial performance na, hindi na applicable ang unenforceable contract. Pag may partial performance na. So, ibig sabihin, if out of the 600 pesos, o sige, ito na yung 10 piso down payment, 10 piso down payment. Kinabukasan, hindi na siya pwede magsabi na unenforceable yun. Kahit na supposedly lumagpas ng 500 at hindi nyo sinulat, hindi na importante hindi nyo sinulat. The fact na merong partial performance or partial delivery, it will be outside the coverage of 1403. Partial performance and partial delivery will excuse the agreement or the contract, or will exclude the agreement or the contract from the coverage of Article 1403 on unenforceable contract. So, ibig sabihin, in short, if there is partial performance or partial payment, it can no longer be considered as an enforceable contract. An unenforceable contract. Hindi na siya unenforceable. Okay? Letter E, an agreement for the leasing for a longer period than 1 year or for the sale of real property or an interest thereon. So kapag dito, nag-usap kayo, tapos ang inyong agreement ay lease ng 1 year, more than 1 year, then you have to reduce it in writing. If not, unenforceable. Sale of real property or interest therein, walang presyo, it must be reduced in writing. If not, unenforceable. Okay? Representation as to the credit of a third person. You mentioned, nagsulat ka. Actually, di ka pa nagsulat. Sinabi mo lang sa kanya, sige na, pautangin mo to. Pautangin mo to. Good credit standing. Yan. There is a representation as to the credit of a third person. Para magkatotoo yung under ano na yan, statement na yan, kailangan yung representation na yan dapat isulat for it to be enforceable. If not, unenforceable yun. Okay? Kaya mga yan, mga unenforceable contract. Ulit, yung performance ay 1 taon pa, guarantee to answer for the debt, default, or miscarriage of another, an agreement made in consideration of marriage, sale of real personal property with a value of more than 500, or at least ba to? Not less than 500, agreement to enter into a lease contract with a period of more than 1 year, sale of real property, and then representation as to the credit of another person. These are unenforceable contracts. And then finally, anong last reason para maging unenforceable ang contract? Both parties are incapable of giving consent. Parehas minor, parehas insane, parehas deaf mute who do not know how to write, or isang minor, isang insane. Yan. Basta parehas kayong incapable of giving consent to a contract, the contract is unenforceable. Pag isa lang ang incapable of giving consent, the contract is voidable. Okay? 1404, unauthorized contracts are governed by Article 1317 and the principles of agency entitled 10 of this book. Okay. 1317, unauthorized contract. To recall, ang sabi ng Article 1317 na pag-usapan natin to before, no one may contract in the name of another without being authorized by the latter or unless he has by law a right to represent him. A contract entered into in the name of another person who has no authority or legal representation and who has acted beyond his power shall be unenforceable unless ratified, expressed, or implied by the person in whose behalf the contract has been executed before its revocation. So napag-aralan natin ito before and in fact meron tayong discussion on this one. Inuulit lang doon sa article yung nature ng unenforceable contract. So, binabanggit niya na Title 10 of this book is on agency. Siyempre, kapag authorized na ang contract, or merong sitwasyon kung saan ang agent ay nag-exceed ng kanyang authority, merong certain provisions yung law on agency on that matter. Basta authority ang issue ninyo, you can always refer to the provisions of the law on agency found on Title 10 of Book number 4 of the Civil Code. Contracts infringing the statute of frauds referred to in number 2, yung pinag-aralan natin, yung in-enumerate natin, are ratified by the failure to object to the presentation of oral evidence to prove the same or by the acceptance of benefit under them. So merong ratification na naman. You all know what ratification means. Pero ano ibig sabihin nito? Paano siya nara-ratify? Sabi niya, by the presentation of oral evidence. So kapag nga si X, sabi ni X kay Y, okay, 1 year from now, actually nag-agree sila eh. 1 year from now, we will enter into a contract of partnership. Pero hindi nila sinulat yung agreement na yan. 1 year from now, di ba? For it to be enforceable, dapat ngayon, isulat natin yan. Okay. Pero dahil hindi na sinulat, supposedly ang status ng kontrata nila ay, yung agreement na yan ay unenforceable. Okay. Nung nag-uusap silang ganyan, andyan si Z, si A, si Q, tsaka si K. Andyan sila. Nag-uusap, naririnig nila, ay, ganun, may agreement sila. Ay, totoo ba yun 1 year from now? Ano daw, partnership? Hindi sinasulat? Hindi sinasulat. Okay. So what will happen? Sabi ni X kay Y, akin na yung, gawa na tayong contract of partnership. Sabi ni Y, hindi. Walang ganun, walang ganun. So supposedly, unenforceable na yan. Yan. Magiging enforceable siya if itong mga to na nakarinig ng usapan nila will testify in court. Lahat sila tetestigo para kay X. Sabi ni Z, A, Q, and K, narinig namin, opo. Totoo po yun, judge. Na sumusumpa po ako sa hukumang ito. Nung si X at si Y ay nag-usap ng panahon na yon, 1 year ago, rinig na rinig po naming apat na talaga pong nagkasundo sila na papasok sa contract of partnership 1 year from the time na narinig namin sila. Totoo po yun. So nagkakaroon ngayon ng presentation of oral evidence to prove the same. Oral evidence, testimony of Z, testimony of A, Q, K, lahat nag-testify, nakikinig yung judge. Aba, so kahit na pala hindi nyo sinulat yan dahil may mga oral evidence dito, then it is ratified. Failure to object. So mag-object ka rin. Kung ikaw si Y, kung ikaw yung lawyer ni Y, mag-object ka. Under the parole evidence rule. Pero hindi nyo kailangang malaman yun. Parole evidence rule ang tawag doon. Or by the acceptance of the benefit under them. Pag ganun uli, no? Kapag pinilit mo, hiningi mo, kunyari si X na si Y, nag-usap, tawag dito, contract of lease. Period of 2 years. Contract of years. Contract of lease for 2 years. Ano yan? Dapat nakasulat for it to be enforceable. Pag hindi nakasulat, unenforceable. So supposedly unenforceable na. Pero si Y, naniningil ng upa. Aka na yung upa. Kapag nagbayad si X, pwede pa bang ipilit na yan ay unenforceable? Hindi na. You already accepted the benefit under the contract. So ratified na yun. It is already cleansed of the defect of it being unenforceable. So again, may dalawang paraan para ma-ratify ang unenforceable contract. Failure to object to the presentation of oral evidence and accepting a benefit under an unenforceable, supposedly unenforceable contract. 1406, when a contract is enforceable under the statute of frauds and a public document is required for registration in the registry of deeds, the parties may avail themselves of the right under 1357, and that right is to compel the other person to execute the necessary document. Again, mangyayari lang yan kung enforceable siya. If the contract is unenforceable, hindi mo siya pwedeng pilitin na i-observe yung required formality para maging enforceable siya. Kung unenforceable siya sa simula, hindi mo siya pwedeng sabihin, sige, isulat na natin para maging enforceable na. No, hindi ganun yung paraan. Hindi mangyayari yan. Pag in-insist ng kabila, hindi, unenforceable yan. Bakit? Kasi walang kasulatan eh. Hindi isulat natin ngayon. Hindi. That is not proper. You can only compel the other person to observe the required formality. Kunyari, kailangan isulat, magagawa mo lang yan if enforceable siya to begin with. And valid, syempre. And valid. 1407. In a contract where both parties are incapable of giving consent, express and implied or implied ratification by the parent, guardian of one of the contracting parties shall give the contract the same effect as if only one is incapacitated. If ratification is made by the parents or both parties, the contract shall be validated from the inception. Okay. X and Y, both incapacitated. Si X minor, si Y ay insane. So ito yung guardian o yung parent ni A, ni X si A, yung guardian ni Y si B. Okay. Kung yung kontrata ay sa pagitan nilang dalawa lamang without the intervention of A and B, the status of the contract is unenforceable. Pero kung ni-ratify ni A to, so okay na on the part of M. Isa na lang daw yung incapable of giving consent, in which case yan ay magiging voidable. Diba? Isa na lang eh, may problema. On the part of A, okay na, na-cure na yung defect by the ratification made by A. So sa kabila na lang. If B will also ratify para dun sa part ni Y, then wala nang defect. Ano na, ratified na yung buong kontrata. At ano yung effect ng ratification? It will retroact. Babalik ka ngayon dun sa unang, as if dun sa simula pa lang, nung nag-uusap pa lang si X at si Y, wala nang problema yung kontrata. Retroactive effect of ratification. Yun tinutukoy ng Article 1407, paragraphs 1 and 2. Unenforceable contracts cannot be assumed by third person. Siyempre, hindi naman sila apektado dito. Eh. Di ba? Yun yung point ng 1408. Ba't ka ba? Problema mo. Di ka kasali dito. So, unenforceable contracts cannot be assumed by third persons. Finally, konti na lang. Void and inexistent contract. Parehas lang ba to? Essentially, parehas lang. Pero let's be technical about it. Pag sinabing void, pag sinabing inexistent muna, may isa, dalawa, o lahat ng elements ng contract ay hindi present. Pag void, present pero illegal. Present pero illegal. Okay. For example, number 1, those whose cause, object, or purpose is contrary to law, morals, good customs, public order, public policy. So ito ay void. Kasi meron pero contrary to law, morals, good customs, public order, public policy. Illegal. Meron pero illegal. Those which are absolutely simulated or fictitious, inexistent. Kasi wala naman talaga. Inexistent siya. Those whose cause or object did not exist at the time of the transaction, inexistent, not void. Hindi siya nag-exist. So kulang ka ng element. Those whose objects are outside the commerce of men. Outside the commerce of men. Inexistent. Kasi wala kang object. Those which contemplate an impossible service, inexistent. Wala kang object. Those for the intention of the parties related to the principal object cannot be ascertained. Wala ka na namang object. Those expressly prohibited or declared by law to be void. This is void. These contracts cannot be ratified. So you cannot claim something that is void. Hindi kayo pwede magkasundo. Sige, okay na lang yun. Kahit illegal, sige, okay lang. Kahit kulang, sige, okay. Hindi pwede. Even both of you will agree. Okay na yun. Hindi pwede. Cannot ratify a void contract or inexistent contract. No right will arise out of a void or inexistent contract. Neither can the right to set up the defense of illegality be waived. Ibig sabihin, hindi mo siya pwedeng i-forgo. Sige, okay lang. Hindi ko to questionin. Sabi niyang ganon. Tuloy lang natin to. I will waive my right to raise the defense of illegality. Sige, tuloy lang. No, it cannot be waived. Okay? You can always say illegal to. Illegal to. And your right to raise the defense of illegality, hindi yung pwedeng pakawalan. Hindi yung pwedeng pakawalan. Yun yung point ng dulo. Okay, isa-isa uli natin ha. Si number one, alam na natin to, no? This is not the first time that we encounter itong series of words na ito, law, morals, good customs, public order, public policy. So kung ang cause, object, or purpose mo ay contrary to those enumeration, we all know the effect, it is illegal, and it will render it void. Okay? Those which are absolutely simulated, wala naman talagang kontrata, pero they make it appear na meron, pero wala naman talaga, so void siya. Again, meron tong kakaiba, yung, anong tawag dito? Absolute simulation at saka, ano ba yung tawag dun sa isang simulation? Relative simulation. Okay? So iba pag relative simulation, pag absolute simulation, void or inexistent. Number 3, those whose cause or object did not exist at the time of the transaction. So don't confuse this with future objects. The future things can be the subject of a contract. Okay lang yun. Mangyari pa siya in the future. Pero if they did not exist at that time, ibig sabihin, wala talagang pagkakataon na in the future mangyayari siya. Yung example ko nito before, may inimport ako, no, mga produkto coming from China. They are en route, no? They are, tawag dito, in transit to the Philippines. Gusto mo bumili. No? Nagkaroon sila ng contract of sale. But they did not know na both of them, di nila alam na lumubog na pala yung barko at wala na yung mga object na kanyang in-import. So at that time, the object did not exist. Wala na yun at the time of the transaction. So wala kang pinag-uusapan at that time. So, kulang ng element. Outside the commerce of men, so binibenta mo yung moon. Yung moon, nakita mo yung moon, akin yan eh. Benta ko sa'yo. Sa Mars, no, nauna na daw yung yung isang senadora doon. Nagkakamkam na daw ng lupa sa Mars para gawing subdivision na portion ng Mars. Nauna na. Outside the commerce of men, hindi pwede. Those which contemplate an impossible service. Nag-usap kayo, barilin mo siya. Again, may dalawang impossibility, legal and physical. Yun ay legal impossibility. Pwedeng magbabaril, syempre, pero physically, kayang gawin. Pero if you have no, generally, kung mapapatay mo siya, it may amount to homicide. So, legally impossible yun. Physical impossibility, you hold your breath for 10 days. That's physically impossible. Or you fly to the moon using your wings. Yeah. Or you make yourself disappear right now. Teleport second floor. Mga physical impossible na yun. Those were the intention of the parties relative to the principal object cannot be ascertained. Talagang hindi nyo maintindihan kung ano ba talaga yun. Diba sa interpretation, sabi natin, if kahit anong gawin niyo, babalik-baliktad na kayo, hindi nyo pa rin ma-ascertain yung kanilang intention. Void na yun. Kasi kulang na ng element yan. And those expressly prohibited or declared void by law. Talagang pinagbabawal ng batas. So for example, under the, ano ba mga, may prohibition. Isip ako ng example. For example, beneficiaryo kayo ng emancipation patent para siyang form of agrarian reform law. Nakalagay doon that hindi mo siya pwedeng i-transfer for a period of 10 years. 10 years, so may prohibition. Beneficiaryo ka, 10 taon hindi mo siya pwedeng ibenta sa iba. Yun yung purpose ng agrarian reform para meron kang lupa na sasakahin mo. So, ibebenta mo siya, madi-defeat yung purpose. So may prohibition. If you will sell it within the 10-year prohibitive period, then that sale is contrary to law. Diba sabi bawal eh. Pero binenta mo pa rin within that 10-year period. So, it is declared void by law. Again, to reiterate, to highlight, you cannot ratify this act. So kahit mag-agree pa kayong dalawa, sige okay lang, sige lang, go lang tayong dalawa. Agree ka ba doon? No, both of you cannot agree. You cannot ratify this void and inexistent contract. And your right to ask for its, to raise the defense of illegality, you cannot waive it. The action or defense for the declaration of inexistence of a contract does not prescribe. So, kanina, di ba, para mapa-declare mo as yung right of rescission, 4 na taon. Right of annulment, 4 na taon. Ito, yung right mo to raise the defense na isang kontrata ay void in existence ay hindi magpe-prescribe. So kahit 10 taon na yung lumipas, 15 years na yung lumipas, you can always say, void naman yun eh. Talagang hindi ako nagbayad, void naman yun. Subject matter namin, shabu. Void yun, kaya hindi ako nagbayad. So, anytime you can raise the defense that it is void and inexistent, and that action or defense will not prescribe. When the nullity of the proceeds when the nullity proceeds from the illegality of the cause or the object, and the act constitutes a criminal offense, both parties being a pari delicto, in pari delicto, they shall have no action against each other, and both shall be prosecuted. Moreover, the provisions of the penal code, revised penal code natin, relative to the disposal of the effect or instrument, shall be applicable to the things or the price of the contract. Pag sabing in pari delicto, parehas kayo may kasalanan. Parehas kayo may kasalanan. For example, si X at si Y, nag-agree sila na magbentahan ng shabu. X will pay 10 million. Y will deliver 1 kilo of shabu. 10 kilos of shabu. I don't know kung magkano siya. 10 kilos of shabu. After ng exchange, na-discover ni Y na yung 1 million 10 million ni X ay fake. Fake bills pala. Falsified. Peke yung mga perang binigay niya. Nung nakuha ni X yung shabu from Y, nalaman niya na ito pala ay pulbos. Pulbo lang pala yun. Powder. Pulbo lang. Or tawas lang pala. Tawas. So para sa nagkalokohan, no? They are in pari delicto, and both constitute a criminal offense. So ano mangyayari? Hindi na pwedeng kasuhan. Bukas lang si Raulo pag nagkasuhan sila. Sabi ni X, kasuhan kita, way, dineliver mo pala sa akin. Tawas, darog na tawas eh. Subong kita sa korte. O si Y naman, ikaw din naman eh. Kasuhan kita, peke yung binigay mo sa akin. Walang ganun ha. They don't have a cause of action against each other. Meron kasi tayong principle in law that those who come to court must come with clean hands. Kapag meron ka daw, pupunta ka daw sa korte para humingi ng tulong sa korte, dapat malinis ang iyong mga kamay. Those who come to court must come with clean hands. So, bago ka pumunta, punta ka muna ng CR. Hugas ka muna. I have clean hands. Literally. Required na rin yun. Kasi na may kumakalat na sakit. You have to go to court with clean hands. Magugas ka muna para stop the spread of the disease. Pero literal yon. Ito, figuratively, hindi ka pwedeng pumunta sa korte kung ikaw mismo may kasalanan. Ano daw gagawin? O parehas kayong ipoprosecute. Total, parehas kayong criminal eh. Parehas kayong ipoprosecute. Tapos, kung ano man yung mga subject matter ng krimen ninyong dalawa ay i-dispose in accordance with the revised penal code. Okay. This rule shall be applicable when only one of the parties is guilty, but the innocent one may claim what he has given and shall not be bound to comply with his promise. So, kung yung isa lang yung yung guilty, then the other one who is innocent did not comply with the provision of the previous paragraph. Okay. Pwede niya pang mabawi yung binigay niya. Again, kung innocent siya, di naman niya alam. It pays to be innocent. 1412, if the act in which the unlawful or forbidden cause is not criminal, dun sa ito, 1411 criminal, ito hindi. When the fault is on the part of both contracting parties, in pari delicto na naman sila, neither may recover what he has given by virtue of the contract. Both. So walang makakabawi. Tapos kayo may kasalanan eh. Okay. When only one of the contracting parties is at fault, so yung isa innocent, yung isa guilty, the guilty person, the guilty party cannot recover what he has given by reason of the contract or ask for its fulfillment. Hindi rin niya pwedeng hingin yan kasi void and inexistent na yung contract. The other, who is innocent, may demand for the return of what he has given without any obligation to comply with this promise. It pays to be innocent. Pwede mo mabawi yung binigay mo na, kung di mo naman alam na illegal pala yung nangyayari, at hindi ka rin required na i-perform pa yung part mo sa obligation. That's 1412. Okay. 1413 onwards ay mga example, no? Specific example ng mga void and inexistent contract. Okay, 1413. Actually, man masyadong applicable to, pero basahin natin. Interest paid in excess of the interest allowed by the usury laws may be recovered by the debtor with interest thereon from the date of the payment. Bakit hindi applicable tong 1413? Because as of the moment, we do not have a usury law. Ano ibig sabihin ng usury law? A usury law is a law which sets a ceiling on or a maximum, uh, sets a maximum with respect to the stipulation to pay interest. So for example, kunyari lang merong usury law, sabi niya, ang maximum na pwede niyong i-charge na interest ay 7%. Pag ikaw nag-charge ka ng interest na mas mataas 7%, yung excess ay void. Kasi based on the usury law, hanggang 7% lang. Up to yung first 7% mo, valid pa rin naman yun kasi compliant siya with the usury law. Pero any interest in excess of the interest allowed under the usury law is considered void and you are not entitled to receive that. The debtor may recover it with interest thereon. Again, walang usury lang ngayon. Walang usury law ngayon, kaya effectively 1413 is of no use. 1414. When money is paid or property delivered for an illegal purpose, the contract may be repudiated by one of the parties before the purpose has been accomplished or before any damage has been caused to a third person. In such a case, the courts may, if the public interest will be subserved, allow the party repudiating the contract to recover. So, ang tawag dito ay spontaneous desistance. Pag sabing spontaneous desistance, bago matuloy yung kontrata, napadalawang isip ka. Tama ba itong gagawin ko? Okay ba ito? Parang nung una nasilaw ka lang naman eh. Sabi, babayaran kita gantong amount. Pekein mo yung pirma. Parang ganun. Parang kaya ko naman magpeke ng pirma. Kaya pumayag ako nung una. Pero isip-isip ako, pero yung madam, bigat pala to sa damdamin. Ayoko na. Nirepudiate mo na siya before the purpose has been accomplished. Bago niya magawa ang inyong gustong gawin. Or before any damage has been caused to a third person. Binawi mo na. Ayoko na. So okay lang yun. Hindi ka paparusahan dahil bago i-commit yung crime, umurong ka na. Very good. Binulungan ka ng guardian angel. May masama yung ginagawa mo. Tigil mo na yun. Sige po. 1415, where one of the parties to an illegal contract is incapable of giving consent, the courts may, if the interest of justice so demands, allow recovery of money or property delivered by the incapacitated person. Again, kapag ikaw incapacitated, di mo alam yung ginagawa mo. That's the presumption. You don't know what you are doing. So even if illegal yung contract and void and inexistent siya, dahil di mo nga naintindihan yung ginagawa mo, you will be given the right to recover. Okay. So, yun lang naman yung point ng 1415. Pagbigyan natin itong mga batang to, total hindi nila alam ang kanilang ginagawa or incapable sila of giving consent. Insane sila, definite sila who do not know how to write. So, let them recover what they have delivered. Speaking of, no, people incapable of giving consent participating in an illegal contract, what is the status of the contract? Is it voidable or void? Para isipin mo, voidable to kasi yung isa incapacitated. Eh. Void to kasi illegal yung contract. So recall natin yung valid, rescissible, voidable, um, unenforceable, and void. Yun yung spectrum mo, di ba? Pinakamaayos sa pinakamalala. Valid, rescissible, voidable, unenforceable, and then void. Kapag ganun ba dapat yung kakamay ko? Hindi ko alam. Hindi ko nakikita. Ganun. Kapag yung defect ay present na defect ay tawag dito, indicates two or more defective contracts. Yung status niya ay yung pinakamalala. So for example, ito nga, there is one of the parties ay incapable of giving consent, which supposedly would render it only voidable, but the subject matter of the contract is illegal, which would render it void. So anong status ng contract, voidable or void? Actually, parehas naman siya. It is voidable and void. But if you have to choose between the two, it has to be void. Because yun yung pinakamalalang sitwasyon. O nagbentahan kayo, for example, shabu, value 1 million. Sabi, para yan ay maging enforceable, it must be in writing. Kasi 500 pesos lang naman yung threshold. Hindi nyo sinulat. So it is unenforceable at the same time void. Unenforceable kasi statute of frauds. Void kasi subject matter of the contract is shabu, illegal. So ano siya, unenforceable or void? Again, it's both. It's unenforceable and void. But you have to choose between unenforceable and void. Dun ka sa pinakamalala. Void siya. Okay? 1416. If the agreement is not illegal per se. Pag sabing per se, in itself, illegal talaga. Talagang hindi mo kailangan ng batas para sabihin na illegal to. The agreement is not illegal per se but only prohibited. So for example, pag-operate ng comedy bar during the pandemic. Pag-operate ng comedy bar during the pandemic. So, yung operation ng comedy bar is not illegal per se. Diba? But it is prohibited. It is prohibited, pero hindi naman talaga siya masama in itself. Hindi siya masama in itself. Nagkataon lang na sa panahon natin ngayon, kailangan natin siyang ipagbawal. And the prohibition by law is designed for the protection of the plaintiff. He may, if public policy, is thereby enhanced, recover what he has paid or delivered. Yan. So for example, para maging maayos yung example natin, ang kontrata ay pagbebenta ng liquor during the liquor ban sa alak. May liquor ban. During the pandemic, nagkaroon ng liquor ban. So, sale of liquor is not illegal per se. Ina-allow siya, pwede ka magbenta ng liquor. Kaya lang, kung may liquor ban, it's prohibited. Okay. Sa extra kasi why nagbentahan ng liquor, ng alak during the liquor ban. Okay. So, the plaintiff, yung nagkaso, may if public policy lang naman will be enhanced. So meron siyang requirement. If and only if the public policy is enhanced, may recover what he has paid. In this case, I don't think they will be able to recover kasi the public policy will not be enhanced. Pero kung sakali lang, I cannot think of an example right now. I-assess mo muna. Pag pinabalik ko ba to, will the public policy be enhanced? So if your answer is yes, then the plaintiff can recover what he has paid or delivered. Okay, ito naman, price ceiling. 1417, especially ngayon uli, pandemic, or during times of calamity or emergency. Yung ano natin, yung gobyerno natin, nag-release yan ng mga price freeze. Freeze. O kaya SRP. Diba? Naglalabas sila ng SRP for basic goods and necessities. Na nagsimula yung pandemic, may SRP yung mga delata, yung alcohol, etc. etc. So kapag merong yung presyo niyan ay merong ceiling or determined by statute, merong batas nagsasabi na ganito dapat ang presyo niya, the amount in excess is illegal and you may recover. So kunyari ang SRP ay 100 pesos lang, binibenta siya ng 1,000 sa'yo, illegal. Ang alin, yung 900 lang naman. So yung 900 pwede mo bawiin in accordance with Article 1417. Kasi lagpas siya doon sa presyong itinakda ng batas. 1418, labor law naman ito. Sa labor law, sabi 40 hours dapat per week ang trabaho. When the law fixes or authorizes the fixing of maximum number of hours of labor, sa Labor Code 40, and the contract is entered into whereby the laborer undertakes to work longer, pwede siya manghingi for, kahit na mag-agree pa siya actually. Sabi niya, sige, okay lang sa akin, every week 48 hours ako. At hindi ko sisingilin yung lagpas na 8. Pumirma siya. Sige po, okay lang sa akin, kahit 48 hours ako magtrabaho, 40 hours lang yung bayad. Pumirma siya. So that agreement is void. Diba? And he can recover, kahit na pumirma pa siya, he can recover yung additional payment for the 8 hours na nag-render siya. 1419, minimum wage. So I don't know the minimum wage right now. 400 something. Or 500. Let me check. So mali pala ako. 537. NCR to ha. Ang minimum wage kasi is regional eh. Sa bawat region may kanya-kanyang minimum wage. Okay. So if they will agree to accept a wage lower than the minimum, kaya nga siya minimum kasi may mababa ka. Ewan ko, di ba naintindihan yung ganong klaseng agreement. Pero anyway, yung isa kailangan daw niya ng trabaho, kaya sabi sa kanya, 500 lang dito ah. Sige na po, okay lang. Pipirma na ako sa kontrata. May maiuwi akong 500 kada araw. So, yung agreement na yon to receive lower a salary which is lower than the minimum is void. And at dahil void yon, you can recover yung kulang. Yung 37 per day mo, pwede mong bawiin yun. Kahit nag-agree ka pa. Kahit pumirma ka pa ng kontrata na nagsasabing pumapayag kang mabayaran ng lower than minimum. Kapag indivisible ang contract, alam niyo na yung indivisible contract. No? May mga portion na pwede mong illegal, yung iba hindi. Kunyari, may portion. Una, 2 portion lang to deliver food. Yung pangalawa, to deliver shabu. For a consideration of 1 million, you deliver food and shabu. Forget mo na yung shabu. Hindi pwede yan. Pero yung food, dahil legal naman yan, it can be separated, it can be divided, can be performed independent of the other, then tuloy mo lang yung food. Pero yung shabu, wala na yan. 1420. 1421, defense of illegality is not available to third persons. And they are not affected. Ganun uli, katulad ng unenforceable contract, they are not affected eh. Void yung contract. Sa kami lang yun. Kami, between us. Hindi ka naman apektado nung aming kontrata. Unless apektado ka. If naapektuhan ka, then okay lang. Pero in between us, hindi siya. Kung kami lang naman yung naapektuhan, hindi mo siya pwedeng gamitin. Yung defense of illegality. So if a contract is a direct result of a previous illegal contract, the subsequent contract is also void. So kung manganganak yung kontrata ninyo, na iba, kunyari, novation. If the contract is a direct result of a previous illegal contract, kinancel nyo, palitan natin yung subject matter, gawin natin legal. Yung subsequent contract ninyo is also void. Again, you cannot derive something legal from a contract which is already considered as illegal unless divisible siya. Pwede yun. Pero kung hindi siya divisible, illegal siya, you cannot do anything about it. You cannot reform it, you cannot interpret it, you can innovate it. Kalimutan nyo na yun. So, an illegal contract. So, void na rin yung mga kasunod nyo. Oh, that's it. So, hopefully, no, may natutunan naman kayo sa pakikinig ng aking lecture. And, yun. Thank you for listening. Goodbye. Bye-bye.